Hello, welcome to my talk on an introduction to patenting computer-implemented inventions from our series of talks on intellectual property. I'm Scott King, a European and UK patent attorney in the Computer Technology Group here at GJE. And GJE is a specialist IP law firm, and I am based in London. So in these talks, which are split into three parts, I'm going to give you an introduction to patenting computer-implemented inventions. I'm going to tackle and hopefully dispel some of the myths that surround patenting software. I'm going to cover the following topics. In the first part, I'm going to talk you through the approaches by the European and UK patent offices towards computer-implemented inventions and what considerations should be taken when thinking of filing a patent application in these jurisdictions. In the second part, I'll go through some example computer technology ideas and see how the different patent offices would handle each of these innovations. And in the final part, I'll discuss IP strategy considerations for computer tech companies. So first of all, let's take a bit of a refresher. For those of you who've watched our other webinars in this series, you may be familiar with the requirements of patentability, or you may already be aware of them anyway. But as they're so fundamental, let's remind ourselves of them first. So there's three main requirements to obtain a patent. Firstly, novelty. So the invention must be new. By the fact that you've got far enough to be considering patent protection, you're likely to be of the opinion that your innovation has not been done before and meets this hurdle. Secondly, the invention needs to be inventive or non-obvious. And this is a harder hurdle to overcome than novelty. And this is whether your invention would be obvious to someone based on what is already known. And this can be a bit subjective. And a lot of a patent attorney's job is arguing with the patent office as to why their client's invention is inventive. And the final requirement is that the invention must be susceptible for industrial application. And this is a mere formality, and it's used by the patent office to weed out things that they feel shouldn't be patented, such as perpetual motion machines. So all computer tech inventions should hopefully easily overcome this requirement. So you think that your invention meets the above requirements? So is your invention patentable? I hear you ask. Well, no, not necessarily. And you may have heard a myth that surrounds patenting software, and it's something that we hear quite a lot, but patents can't be obtained for software, and you have to rely on the weaker form of protection offered by copyright. However, lots of tech companies these days are exploiting the digital age, and this myth might put off a lot of startups from seeking patent protection, which would undermine the hard work that they've put into their R&D and ruin their potential advantage they have over their competitors. However, as you can see here, the number of computer technology patents in 2019 was over 12,000. So this myth is clearly not true, or otherwise these 12,000 patent applications will have been filed and have no hope of being granted, which would be a huge waste of money. In fact, looking at the statistics shows a promising picture for computing technology and patents. So computer technology was the second fastest growing field at the EPO in 2019. And here the driving factor for growth was the increase in patent applications related to artificial intelligence, especially in the areas of machine learning and data recognition. And image data processing and generation and data retrieval also saw notable increases. In addition, computer technology patents was the third highest field of patent applications at the EPO, behind, in first place, digital communications, so telecoms, and in second place, medical technology. And here we have the list of top applicants at the EPO in the area of computer technology in 2019. So as you'd expect, the top few filers are the familiar names we'd expect to see. So Google's parent company, Alphabet, and Microsoft are in joint first place with 673 applications each. And behind them are the big telecoms names, Samsung and Huawei. And US companies accounted for nearly 40% of all patent applications in 2019, which was a huge proportion and maybe not surprising. And this was followed by EPO member states with almost 30% of the total European applications. And applications from China made up just over 10%, and this is increasing year on year. So the big names are clearly taking filing patent applications for their computer tech inventions seriously. So it's important that we dispel this myth that we've just seen, so smaller startups and smaller companies can do the same to avoid being left behind. So where does this myth that patenting software is not possible come from? So let's look at the law in the UK and European patent offices to find out. Well, there's a reasonable explanation of where this myth may have originated, and it's all to do with these exclusions from patentability. So according to European patent law and UK patent law, which mirrors this, there are a number of exceptions that are not considered to be inventions, despite meeting the requirements that we've already discussed of novelty, inventive step, and industrial applicability. So these exceptions include discoveries, scientific theories and mathematical methods, aesthetic creations, schemes, rules and methods performing mental acts, playing games or doing business, programs for computers, and presentation of information. So the one that we're largely interested in is programs for computers. And this is where the belief that the computer programs or software is not patentable comes from. So why are these software exclusions there? Well, you might think that some of these exclusions make perfect sense. For instance, a mathematical method or a scientific theory, they seem reasonable to exclude, as why should someone be allowed a monopoly on a new physics equation or mathematical proof? However, given that computer programs and software make up so much of technology, you can be forgiven for thinking that it's unreasonable to exclude this area. Well, firstly, patent law isn't new. The European and UK patent law that we've just seen was drafted in the 1970s, where computers were in their infancy and were not like they are today. Another reason for this exclusion is that computer programs were thought to have been protected by copyright, a different form of IP right. So copyright exists for written words, and computer programs in their raw form are written down. And another reason is that people give is that computer programs are algorithms, which is a type of mathematical method, so shouldn't be protectable by patents. And also, in the early days of computers, there was also difficulty in searching, which was a problem, as the availability of published techniques and the ability to keep code secret meant that patent offices were reluctant to give broad monopolies for software, as they were unable to determine what was already known. However, as we know, computer programs these days have changed significantly since the 1970s. Copyright no longer provides sufficient protection, as it only protects the expression of the computer program. It doesn't protect the concept behind it. And searching capabilities are also now much better. However, thankfully, the law does provide us with a get out of jail free card, such as a list of exclusions are not the end of the story. There's an additional final point that a patent application is only excluded to the extent that the European patent application or European patent relates to such subject matter or activities as such. And this is an important point to note, as if the invention relates to something more than a computer program or one of these excluded things, then innovation in itself isn't excluded from patentability. And this as such is also present in the UK law. So when the European Patent Office assesses whether something is excluded, if the invention contains a mix of technical and non-technical features, then it's not immediately objected to as being excluded. However, it still must pass the test that the invention must provide a technical effect. And the European Patent Office would make this objection under the banner of inventive step, one of the requirements that we've already seen. And the EPO handles inventive step using the problem and solution approach. So this approach involves asking these three questions. So firstly, what are the differences between the invention and what is known? What is the effect of those differences? And is this effect technical in nature? So what is key here is it must have a technical effect in a technical field. Therefore, the question we have to deal with a lot is determining if something's excluded is what is technical, and does our invention fall within the bounds of something that's determined to be technical? So there's no real definition of the meaning of technical, and we have to determine this based on previous case law. So a good way to understand what is technical is to first of all think of things that are perhaps not technical. So contributions in the field of excluded matter will be non-technical in nature. Advantages and effects that are limited to business methods are also likely to be non-technical in nature. And it's sometimes helpful to think who would have been the person that would come up with the idea. Would it be a technical person, such as a scientist or an engineer, or whether the idea would have been come up with by a business person? And if it's a business person's idea, then it's likely to be determined to be non-technical. So in the next talk, I'm going to run through some examples of example computer tech ideas and see whether they're technical or non-technical. So thank you for your time. In this talk, I provided you with an overview of patenting computer implemented inventions and hopefully dispelled a myth that's out there. If you'd like to find out more, please watch some of our other talks in this series. Please find details of our website, or feel free to email me or add me in LinkedIn. Thank you.